Hi everybody, Scott Nell here with the Scott Nell team. We're here today with Jamie Gonzalez, who's with Oldman, Cooley, Salas, Brinberg, Coleman, and Gold. She's an amazing trust attorney, and today our topic is how does the probate process work in real estate? So she's going to take us through the process. So the stage is yours. Talk to us about the probate process and what we need to know.
Sure. So when a person is being appointed as administrator of a probate estate, they will either seek full authority or limited authority. Most often you get limited authority. What the difference is with full authority you can actually sell real property without a court order. If you have limited authority, you need a court order to sell it.
Okay.
But if you don't have a will, you will get limited authority. If you have an administrator who is out of state, you will also get limited authority. You may get full authority when you have a will that specifically states that either you can sell real property without a court order or it provides that you may have full authority. But more often than not, an administrator would get limited authority. If you have full authority, an administrator can still seek court approval for the sale of real property. Why would they want to do that if they have this authority to sell it without the court approval? Two reasons. One, just for extra protection, so no beneficiary can come back and say either you didn't sell it for a high enough price, or I don't like that buyer, or I don't like the conditions that were put on it, or something like that. Another reason would be to try and get overbids. There's a whole overbid process in the probate court, so you can get potentially you could get a higher price if you go through the overbidding process. So that may be reasons why an administrator who had full authority would still want to go get court approval. If you have full authority and you opt not to get court approval, you are still required to give notice of what's called a notice of proposed action. It's a specific form. It advises all persons who are interested in the estate that you plan to sell this property, and it gives all the details, the assessor's parcel number and the legal description and those types of things.
How is that notice given?
It's a written form, and the attorney, the administrator will likely have an attorney. The attorney will write it up. It's typically a one-page form, and then there's a second page that's divided into two parts. The top part says, I consent to this proposed action, and the bottom part says, I object. So you send it out to anybody who may have an interest in this estate. They have 15 days to either consent, object, or do nothing. If they consent and all the beneficiaries or interested persons consent, great. If they do nothing, then after 15 days passes, the administrator can move forward and sell the property and assume consent, assume that the beneficiaries had consented. If somebody objects, however, then the administrator must then go into court and seek court approval. And the objecting party would then have to give reasons why they object, and then it would go through the court process.
How often does that happen that someone objects?
Well, it's definitely a case-by-case basis. It depends if all the family members get along, if there's dysfunction in the family or parties who don't get along. So it's kind of hard to say. It's definitely a case-by-case basis, but it's not unusual. I'll say that.
Okay.
So let's see. If you are selling the real property with court approval, there's a whole process that you have to go through to get the court approval. So the first thing is, and this is super important, find a real estate broker with probate sales experience.
You heard the lady.
You technically can get any real estate broker, but it behooves an administrator to find somebody with probate experience because it will save you headache and money down the road.
Right.
And the reason it saves you money is because, when you sign with a broker and do a listing agreement, there's a whole bunch of forms. When you go through the probate process, there's specific forms and specific clauses that must be included that real estate brokers who aren't in this realm wouldn't know about.
Right.
And your attorney is going to have to review everything. Now, in the probate process, for many administrative things, the attorney simply gets a straightforward statutory fee. But there are certain categories, one of which is sale of real property, where an attorney can get what's called extraordinary fees. And that's where they can just charge hourly for whatever that they do in this category of sale of real property.
Okay.
And if they're having to review and revise listing agreements without the proper paperwork and the proper clauses and stuff like that, it's going to increase your attorney's fees by a lot.
Right.
So that's why you want to find a broker with probate experience. I'm sorry, after all of the documents are signed and everything's ready to go, the broker needs to market the property, and you're going to have to show down the road everything that the broker did to market. So they really need to be actively involved in various avenues of marketing. They should state in the marketing paperwork that the sale is subject to court approval and overbids. And during this process, you can review offers, but you cannot accept them yet. Part of what you have to do in the probate process is you have to publish notice of the sale. So the requirement is that you have to publish it 3 times in a local newspaper. There's specific statutes that govern all of this. The first and last publication cannot be within 5 days. It has to be longer than 5 days apart. You can publish once a week or more often, so long as the first and third publication are not within 5 days of each other.
So who's the one that submits that?
The attorney does that, and it's just a form that we submit to the newspapers. And in part of the publication is you're going to put a sale date, a specific sale date that needs to be sufficiently far out for this publication to have been completed, and you cannot accept offers prior to that date. So like I said before, you can be reviewing the offers, but you cannot accept the offers. And you're going to have to prove to the court that you have completed this publication and file a specific form with the court showing that.
And what happens if you don't follow that procedure?
Your sale is not going to be approved.
Which is why you need an experienced attorney.
And an experienced broker.
There you go. It's all about the team.
Right, exactly.
Hey everyone, if you'd like more information about myself or my amazing team, check out scottnellteam.com or subscribe to our YouTube channel. Thanks for watching.